For you to say that this is a hindrance to you and an imposition on you does not guide well with me. Hold on. All right, you're on. Good morning. Why wouldn't you take that off when the bailiff asked you to earlier?
I had told because I had this on. I didn't want to take it off.
I understand, but it's not appropriate. You have to do that and follow the rules. It's not just when you're standing in front of me, but when you walk into the courtroom, there's no head. You should have known better than to wear a bonnet to court in the first place.
Yes,
right? This is felony court, not where you show up in a bonnet.
Right out of the gate, the judge sets the tone. Courtroom decorum isn't about fashion. It's about respect for the process. In felony court especially, presentation matters because it signals seriousness. Do you think this is just about clothing or about attitude? First impressions in court can absolutely shape how a judge views you moving forward.
So, why were you late this morning?
I had to bring I woke up late and I had to get to school, but I had called up here and told them that I was
So, how old are you, Miss Richard?
How old am I? 25.
25. So you're old enough to set an alarm and get up on time.
Yes.
Okay, so getting up late is some excuse that my kids would have, not something that a grown lady that has her own kids would have. You need to be.
And here's the reality check. Judges hear excuses all day long. Transportation issues, oversleeping, confusion about dates. But legally speaking, punctuality is a condition of bond. When you're out on bond, you're on borrowed freedom. Mississippi court, you risk losing it. Simple as that.
You're on time. I'm going to recall that bond forfeiture. And let me get to your case real quick. This is your initial appearance in cause number 25, DCCR 1611. You're charged with theft of property with previous convictions from August 14th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am.
So what I'm going to do, Ms. Richard, is since you made bond, I expect you to at least try to hire a lawyer. So I'm going to reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, then just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts and different payment plans. Bring me the names of the lawyers that you've talked to when you come back so I know you're trying, and then we'll discuss your offer.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you can go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk right here, she'll give you a reset notice.
That's Martin. Martin, she's on an issue.
Miss Martin, come up. All right, ma'am, are you Isis Martin?
Yes, ma'am.
And why were you late?
I was waiting on my ride and I had to find my way up here. Just my first time being here.
Say it again.
I was waiting on my ride and I had to find my way up here. I ain't know what's up.
Okay, so it's very important you get here on time next time.
Yes, ma'am.
I'm going to recall the bond forfeiture. And Miss Martin, this is your initial appearance in cause number 25, DCCR 1827. You're charged with a second-degree felony offense of robbery from October 14th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
All right, so what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so that I know you're trying, and then we'll discuss your option. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you can go back to jail. Do you understand?
Yes.
All right, step in front of the clerk. This one is it just? Good. You're Robert Felix.
Yes, ma'am.
And come on up, ma'am. Let me get this pulled up here. Good. And let's see, this is 21-38610 and 21-38611. Mr. Felix is on probation in each of those cases. One for manufacturing or delivering a controlled substance, and the other for felon in possession of a firearm. Received an administrative hearing from Ms. Shoppa Bradley, and in it, the request was to schedule it for a judicial review. So you were in custody and released December 18th, and the stipulation was that you have a GPS monitoring device with zero tolerance, and it looks like there have been several issues with that monitoring.
Now, this is where things get serious. Manufacturing or delivering a controlled substance plus felon in possession of firearm. Those are heavy felony convictions. Probation isn't a right. It's an alternative to prison. And when GPS monitoring is added, that means the court already had trust concerns. So every violation hits harder.
Company that the battery either hasn't been charged properly. It looks like you were out past curfew. January 2nd, on January 3rd. Also, claim that you have unstable housing. But you're supposed to be giving the information of which of the addresses you're staying at to your probation officer each day. Is that correct? So what's going on?
I really don't know what the addresses I'm staying at. Anytime I was out past curfew was because of work purposes. I was doing that. I gave her the receipts of proof for that. I have a job right now at Sparkling Image. On my CD.
At where?
Sparkling Image Wash Depot. I also DoorDash. I've been on this monitor for 5 years, Judge. I paid over $14,000 since 2021. And the monitor wasn't really hindering me from doing what I need to do. And
well,
like, I make the curfew. I lost my house and everything. That's
well, here's the thing. This was your hold on. For you to say that this is a hindrance to you and an imposition on you does not bode well with me. Hold on. All right. You're on probation for obviously 2 serious felony cases. You have some criminal history, obviously, because you're on probation for an unlawful possession of a firearm by felon. I get that probation's not fun. I get that you have to do things you don't want to do. That's what happens when you commit felonies. So coming in at that angle is...
Watch this shift. The moment the defendant frames a monitor as a hindrance, the judge immediately clamps down. That's because accountability is everything in probation cases. Judges respond far better to ownership than complaints. If you're asking the court for leniency, tone matters just as much as facts.
It's not going to go well, okay? You've had some issues. You were here, and we required that monitor for a reason. And so I'm trying to look back and see, but I'm guessing the reason was that we had some issues with failure to show up, or what was the...
We initially did a judicial review there were some problems with the monitors and getting them to comply. We asked for a judicial review to see if he could get off of it, and he didn't show up for that hearing. And so that's what put him in jail. And then he did get out again. He initially had some trouble keeping it charged and everything, but once it was impressed upon him that this was not going to go away, so what he needed to take care of it. The only problem is it's not feasible to have somebody that has unstable housing do a monitor, and while he's door dashing after 8 o'clock at night. I've checked his receipts. He does DoorDash. He's got receipts saying that he has, I didn't check every single one, Judge.
Sure,
I've spot checked, and he is he's doing it. He's going to school, but this monitor is not except a way for me to try to supervise him.
Okay. So do you think it would be easier for him that you could actually supervise better without it?
I think.
Okay. All right, and here's the thing. It sounds like, Mr. Joseph, if you had showed up the other time you were supposed to be here, that was probably what was going to happen. And then I got mad that you didn't show up, and I'm going to make you keep the GPS. You see, the consequences just get worse and it could have been better.
I showed up last time. They sent me to a different courthouse in Port Arthur. I had the paperwork and everything. I've been screaming for help for years I've been doing it.
You've been coming to, you know what court you're supposed to come to when it's my day for you to come to court because you've been coming since you've been on the probation. So that's not, you know, if there's an issue here where you're supposed to be.
I just filed the last direct report. They sent me to court office and
Who's they?
I had the info.
So here's the thing: things are going kind of well for you. You probably should quit coming up with excuses, okay? Because it's probably one of my number one pet peeves. Is just to keep coming up. Just take the personal responsibility. Went to the wrong place.
This right here is a masterclass in judicial psychology. The judge is basically saying, you almost had this handled. Missing that prior hearing likely cost him months of restriction, one decision, one absence, and consequences snowball. How many legal problems escalate simply because someone didn't show up?
Should have asked a bailiff. You know where the 252nd District Court is. You know the judge that's you're on probation for. So I'm going to, it sounds like you've got some really positive things going on and that you were in a bad place and you're working hard to get out of that. This isn't meant to make it harder on you, but you have to follow the rules and you have to show up, stay in touch. It sounds like your probation officer is willing to work with you through all of this kind of turmoil with you not having a steady place to live. So take advantage of the fact that you've got a good one that's willing to work with you. Make sure you stay in touch with her. Let her know where you're staying. I know that's difficult because if you're changing places, you got to keep telling her. But keep doing all of that. You're going to be fine, okay? So I'm going to I will allow the order that the GPS monitoring device be removed. That makes it all the more important, though, that you stay in touch and she knows what you're doing, where you are, and all of those things. Okay? All right, you're free to go. Thank you, ma'am.
And that's the twist. Despite the tension, despite the pushback, the judge removes a GPS monitor. That's significant. It signals cautious trust. But notice the warning attached. Stay in contact. Follow the rules. No more excuses. In felony probation, freedom isn't permanent. It's conditional. The real question is, will he capitalize on the second chance?
Did you just do one or did you do one in each case?
I did one and said they were running concurrent.
Okay.
At the bottom was like,
Yes.
work.
All right, again, you are Carly Davis. And Ms. Davis, in clause number 25, DCCR 1451, you're charged with a third-degree felony offense of driving while intoxicated from May 6th of 2023. And what that means in that case is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years. And the potential for probation. And then in clause number 25, DCCR 1452, you're also charged with driving while intoxicated, third or more. This one's from February 10th of 2025. Again, if you were found guilty at trial, the range of punishment is between 2 years and up to 10 years. And again, the possibility of probation. Do you understand? And I have a plea bargain rejection here on the tablet that shows that the District Attorney's Office has made an offer in each of your cases. If you wanted to enter pleas of guilty for 10-year sentences that would be probated for 10 years, there would be the required 30 days in jail, and then there is, well, it's 10 days required. Their plea agreement is for 30 days in jail, 90-day inpatient treatment with a drug patch, and those would run concurrently with a $1,500 fine in each case. Is that your understanding of what the offer is? And you have every right to reject that offer and have your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
I do.
And do you want to reject that offer and have both of your cases set for trial?
Yes.
All right, we'll get that done. Ms. Davis, I do want to make sure you understand that after today, I will not accept these plea agreements. Once your case is on the trial docket, it either goes to trial, both of them, or if you did change your mind and want to enter a plea of guilty, it would either be open to the court or to some different plea agreements. Do you understand?
Yes.
All right, and you requested and received all the discovery.
Yes, Judge.
We'll get it set for trial. Stay in touch with Ms. DeLage, and she'll begin preparation for trial. Free to go. Thank you.